Hi everybody, it's attorney Ashley Goggins, and I help men and fathers protect what matters most, their peace, their pockets, and their relationship with their kids. And today is day 5 of the 12 days of free game. It is day 5 of the 12 days of free game. If you have been following along, thank you. Today we are going to be talking about answering or responding to the petition once you are served, okay? So before we get started, we're going to do what we do best, and we are going to take the time and share this out. We're going to make sure we tag a friend, a family member, a coworker, anybody that you know that may be watching this and need this information. So get this shared out. And thank you guys for all of your shares and comments. Thank you guys. Okay, so we are going to get into it. So just to recap, if you are involved in a family law case, the first thing you need to do is consult with a lawyer. Once you consult with your lawyer and you actually need the services of a lawyer, then you should retain a lawyer to help you with the case. Because going back to our first day, you don't know what you don't know. You want to make sure that your rights are protected. You want to make sure that you are complying with all of the deadlines, and you want to ensure that you can at least know that you got a fair shake when it comes to a family law case, whether it be a divorce, a paternity action, time-sharing action, contempt action, whatever the case may be. You want to make sure that your rights are protected. Okay, so you have filed the petition. You have served the other party. The next stage is the answering phase or the response phase, okay? So if you have filed the petition, you are the petitioner, and so you have served the other party. Once that party is served, that party has to now answer the petition, and that party is called the respondent. So if you have been served with a family law petition, you need to respond within the deadline. Listen, not responding does not delay your case. It does not stall your case. It does not make your case disappear. It does not make your case go away. Respond to the petition. Doing nothing hurts you. Doing nothing hurts you. If you are served with any type of petition, you need to respond within the timeline, within the deadline. Not doing so hurts you. The case can proceed most times without you. It is not going to make your case go away. It is not going to delay. It is not going to make things get better. Answer the petition within the time frame. And you probably need to seek out counsel prior to the deadline expiring, especially if it is a child support case, because those deadlines are strict and some of your rights and obligations may have to wait if you wait, okay? Some of your rights may not happen immediately because you waited too late. Some things may be vested, meaning cannot be changed, because you were late and because you did not take action. So when you respond, if you're looking at the petition, you need to read every single line, because you need to know what the other party is requesting. You need to know what relief they're seeking, what allegations they are making. And when you look at the petition, it's going to be paragraph 1, 2, 3. It could be subsections A, B, C. Look at everything, and then you respond to each one of those numbered paragraphs. You can either admit or deny. You can agree or disagree. And once you go through each allegation, then you need to file that answer with the clerk of court. Now, most times you're not going to agree with everything unless this is a completely uncontested case. Otherwise, there are likely going to be some things that you don't agree with. So, disagree. Sometimes you don't have to explain why you agree or disagree. You can simply agree or disagree. You can admit the allegation or deny the allegation. But you need to know what it is important for you to admit to, what is important for you to deny. You don't want to Christmas tree it. And again, you don't want to not respond. Okay, so Also, with your answer, if you're the respondent and there's some relief that you want to see, you need to file a counter petition or a counterclaim with that answer. It's called an answer and counter petition. So you can file your answer to their petition as well as a counter petition outlining the allegations that you want to make and outlining the things that you want. When you file a counter petition, you are asking the court to consider additional things on your behalf. Maybe the petitioner or the party that filed first did not include everything that you think should be brought up. So for example, if you are the wife that was served by a husband, then you want to have spousal support or alimony. You want child support or retroactive child support. You may want an unequal distribution in the equitable distribution for your assets and liabilities. So that would need to be requested. The same for fathers or husbands. I see it all the time where a wife will file or a mother will file and then they don't file anything on their behalf, seeking the relief that they are entitled to and trying to secure their rights. I don't see that. A lot of times when parties are unrepresented, they do not file a counter petition on their behalf. Now, if you file a counter petition, then the other party, the petitioning party who started the case, they have to respond to your petition by admitting or denying or agreeing or disagreeing with the allegations that you outline. Because someone on the other side, the petitioner, may have their side of the story in their petition. You may want your side of the story heard on your side. So each party has to agree or disagree. If you only file an answer, the petitioning party does not have to respond to an answer. They only have to respond to a petition. They only have to respond to a petition. So to recap, once you're served, you have to answer within 20 days, okay? If you're in the state of Florida, 20 days. If you do not file an answer, you run the risk of being held in default. There will be a default judgment filed against you, and the petitioning party can move forward to the end of the case through a final hearing or trial. And what they ask for, if it is legal, they can receive all of the requests that they've asked for in their petition. If you file an answer, you also have the option of filing a counter petition as the responding party. You can do that with your answer, or you can do that after you file your answer. Once you file it, the opposing party or the petitioner has 20 days to respond to your petition, okay? Listen, you don't want to get a default. You want to take action. You want to participate in the proceedings. It will not make the proceedings go away if you don't participate. So participate, okay? Participate by doing what you're supposed to do and doing it within the time periods that are allowed by law. That's most important, okay? And when I tell you this, I mean this, and I'm telling you this from the bottom of my heart. Don't not do anything, okay? Take some action, okay? Take some stake in what has happened, okay? Either that is participating in a family law, a paternity action, a family law divorce, or a child support case. Participate, okay? You want to make sure you are participating so that your side can be heard, okay? Because there are a lot of times where if you don't show up, especially if it's a child support Department of Revenue case and retroactive child support is ordered, there are limited reasons why you would be able to overturn that. Once retroactive child support is established, it is generally going to be vested. Okay, that means it's not going to be changeable. Okay, just because you decided you don't like the number that they had. Okay, or you want credit. All of that has to be done at a hearing. So you want to make sure that you're doing the right thing. Time sharing. If you have kids, there's no reason why you should not be participating. If you have assets or liabilities, it's no reason why you shouldn't be participating. It's no reason other than an uncontested divorce. That is the only time you don't have to file a petition. An answer. Unless you have an uncontested divorce and you reach the settlement with your spouse, you do not have to answer. You can just do a waiver, okay? You don't have to do the whole admit, deny. You can say I admit to everything, but there are certain limited situations where you don't have to file, okay? So I hope that was helpful for you. Again, respond. If you need assistance, reach out to a lawyer. You will not regret just having the information that you need to make an informed decision. It costs you generally nothing sometimes just to get information from somebody that is a professional, okay? And whatever amount that you may have to pay, even if it's for a consultation, it is likely way less than what you could lose or what you could risk. The same thing with retaining a lawyer. You could probably lose way more than what you would pay to have things done the right way. Okay, so go with Goggins. It pays. I will see you guys tomorrow. Happy Sunday and enjoy the rest of your weekend.